not have sufficient seating inside. We are adjourning out here to open the meeting in public so that people can see that, and then we'll move ahead. So the first item would be to ask for an adoption of the minutes as circulated.
So moved, Your Worship.
Second. Discussion? All those in favor? Opposed? Motion carries. And the next item is a procedural motion. If someone would like to move the procedural motion? Okay, sorry. Moving second. We're just moving the procedural motion at this time. Yeah, please. Why don't you do that?
Public in order to deal with the agenda items under the Community Charter, Section 90. Gee, that's...
The volume, please. Can you raise the volume so we can hear you?
We can't. I'm sorry.
Section 9.
I don't have a, but you're talking about his reading it.
Okay, can I get on with it? Section 90, bracket 1. C, labor relations or other employee relations. G, litigation or potential litigation affecting the municipality. I, the receipt of advice that is subject to solicitor-client privilege, including communications necessary for that purpose. N, the consideration of whether a council meeting should be closed under a provision of this subsection or subsection 2. And Community Charter Section 92, or 2 in brackets. B, the consideration of information received and held in confidence relating to negotiations between the municipality and a provincial government, or the federal government, or both, or between a provincial government or the federal government, or both, and a third party.
Second, Your Worship.
And you so moved and seconded. Discussion? Just one sec. Just one sec. Okay. Go ahead now. Try that. Okay. Unfortunately, these weren't set up. So, Councillor McKay, you're on first, unless you want to defer to Councillor Bestwick. Okay. Councillor Bestwick.
Your Worship, the topic that we were intending to be in camera from my perspective is an item that deserves to be clarified and qualified C, G, I, and N on the grounds in which warrant the leader-cast motion of August the 11th to go in camera. I would like an explanation on why we must go in camera. These are bullet points. I would like the specifics and the detail on why we must go in camera.
Okay, and I think maybe Suk, would you like to give the explanation for it, please?
Perhaps this gentleman could be introduced.
Yes, maybe Suk, if you could introduce yourself. You're the city solicitor.
Yes, Your Worship. In terms of the sections of the community charter that are specified in the motion that's been made, labor relations or other employee relations relates to matters relating to the employment circumstances of city staff, and the discussion of those matters, because they can be of a sensitive or confidential matter, are permitted under the statute to be discussed at an in-camera meeting, a closed meeting, as opposed to at a public meeting. And the policy underlying that is that it relates to confidential issues relating to employee relations. So that is the basis of subsection C. Subsection G is litigation or potential litigation affecting the municipality, which is generally invoked by municipalities where there is potential liability or risk of liability to the municipality that the municipality wishes to discuss. And obviously a public discussion of potential liability would be holding your cards not close to your chest, but potentially exposing that risk of liability to the public generally and to the individual where that liability may lie. That is the basis under subsection G. In respect of the receipt of advice that is subject to solicitor-client privilege, clearly I think everybody understands that when counsel receives legal advice that advice is subject to solicitor-client privilege, which means that it is advice that is to be kept confidential unless council decides that it wishes to disclose it. And that is a decision for council as the governing body of the municipality. Obviously, if solicitor-client advice is discussed at a public meeting, council will be waiving that privilege, and as a result, the legal advice will be made public. The final item N, the consideration of whether a council meeting should be closed under provision of this subsection or subsection 2, is a recognition under the legislation that sometimes even the discussion as to whether something should be dealt with at an in-camera meeting is of a sensitive nature, because the only way in which to properly discuss whether it should be dealt with in camera would result in some confidentiality or lack of breach of confidentiality that could be harmful to the interests of the municipality. So even the mere discussion of whether to go in camera can first of all be dealt with at an in-camera meeting.
Please, just let the gentleman speak. Go ahead.
That is the basis under the community charter. Unfortunately, I did not draft the charter, but that is what the provincial government has dictated. And those are the sections that have been identified for council as the basis for dealing with the matters that are proposed to be dealt with in camera at a closed meeting of council.
Okay. Thank you. Do you follow?
I'll default to Councillor McKay.
Councillor McKay.
I may respond following that.
Thank you, Your Worship. Well, first off, I've got a number of questions to ask. First off, may I ask our council if it's true that Section 90 of the Community Charter says that these items may go to council or go in camera at the discretion of council.
Well,
They're not must, as in 92, Section 92.
I am happy to answer your questions. I act on behalf of the corporation. Now, if council as a whole wishes me to answer questions that would be solicitor-client privilege, I'm prepared to answer those in a public meeting. But council has to direct me to give legal advice in a public meeting, which would thus vitiate any solicitor-client privilege. Now, on that specific issue, the statute speaks for itself. I'm not giving away any state secret. The statute says Section 90 sub 1 is a number of permissive areas in which council can go on camera. Under the community charter, the business of council is to be conducted at an open council meeting. The standard, the default is all business of council is to be dealt with at an open meeting. If council wishes to deal with a matter at a closed meeting, council may do so, but only if it fits within one of a number of heads of types of issues that is set out in the statute, and that is permissive. There are some matters, though, that must be dealt with at an in-camera meeting, and those are under Section 90 sub 2 of the statute.
So if I'm correct, then 90 C, G, I, and N are in the permissive or may section.
Yes.
Thank you. Your Worship, I need to go back to July 21st. Unfortunately, an emergent situation arose at my place of employment, and myself and a number of my colleagues weren't able to make that meeting. There was a proclamation made at the beginning of the meeting in the mayor's report, if you recall.
I don't have it in front of me. I don't know whether we can pull it up or not.
Well, you proclaimed during that meeting that later in the meeting, or you proclaimed that due to the fact that we'd been given legal opinion, the item of leadercast notice to motion would go in camera.
That's great.
So the question I have is, what provision of the community charter or procedure bylaws enables the mayor to unilaterally make a decision to move a notice of motion from an agenda of a public meeting to an agenda of a closed meeting?
Well, it's my understanding, and I don't have the minutes in front of me now, but we were dealing with an item of personal nature for employees, and I think that was the concern that we had. There were allegations of wrongdoing on the part of employees, and on the recommendation that from council that we not proceed with it in an open forum, we did so.
Later in that meeting on July 21st, a vote was taken by the members of council that were here that they would go in camera to discuss that issue. My question is not that motion. I can't ask for reconsideration of that motion because it's already been acted upon.
Right.
What I am asking about is the original unilateral statement that was made in the mayor's report where it was stated that due to these legal considerations, it was going to be going in camera. At what point did council make a decision or hold a vote that that would go in camera? It was later in the meeting. So my question is under
I
what
can't recall the
authority in the
sequence,
charter?
but I know that the decision was made based on recommendation from our legal counsel. That's what made the recommendation for it.
Well, unfortunately, with all due respect to our legal counsel, they don't run our meetings, we do. I'm asking the question, what provision of the charter or our procedure bylaws allows a unilateral statement to be made that this is going to go in camera, and we'll vote on it at item number 17 later in the agenda?
As the chair, would I have authority for that, in your opinion?
Again, if council wishes me to give legal advice to council as a whole, I am prepared to do that, but council has to indicate to me that they wish me to do so in a
Okay, well,
public
then let's
forum.
ask for a motion if you'd like to hear a legal opinion right now.
I'll make that motion.
That you want to hear it?
That I want to do.
Okay. Move and second. Discussion? Okay. All those in favor? Opposed? Motion carries. Go ahead.
All right. In terms of the procedure bylaw and council procedure, the agenda for council meetings is set by the mayor and in consultation with staff. The issue in respect of the notice of motion which was made raised issues of concern for myself as the city solicitor in terms of the corporate interests of the city of Nanaimo in relation to potential liability and in relation to human resource issues. Now, I am not the city's human resources lawyer, but it did raise sufficient concerns for me, such that I suggested to the mayor, as the chief executive officer of the municipality, that the matter, that council may want to consider dealing with the matter in camera. And that's what I understand occurred at that council meeting, was that the mayor was indicating that after discussion with myself, there was concern as to dealing with the notice of motion at a public meeting, and at that point there was discussion of taking it in camera, and then the appropriate resolutions were passed. Now, I was not at that meeting, but that's my understanding.
As our corporate counsel, can you answer the question directly? What provision of the charter or our procedural bylaw allowed the mayor to unilaterally make a decision to move the notice of motion from an agenda of a public meeting in camera? What gave us the authority to do that?
My understanding of the community charter and the procedure bylaw of the city is that the mayor is responsible for the agenda of council's minutes, council's meetings, and that the mayor, as the head and chief executive officer of the municipality, has overarching jurisdiction, if I can put it that way, in terms of the leadership in terms of the interests of the municipality. And that's what I would suggest.
So then can we see the provision within our procedural bylaw or the charter that states that?
Well, the provision of the charter simply states that the mayor is the head and chief executive officer of the municipality. And there are provisions, the provisions of the community charter specifically set out what the mayor's responsibilities are, including providing the, overseeing the stewardship of the municipality. That's not a direct quote of this section.
Well, personally, I thought we were all responsible for that, but in any case, I'll move on to my next question. Subsequent to that, our minutes and our video of the previous meeting where the notice of motion was read out have been redacted. And in fact, on our minutes of that meeting, there's no notion or no mention of the notice to motion. So my next question then is, what provision of the community charter procedure bylaws enables our staff to make a decision to alter the public record?
Well, again, we did discuss this, you'll recall, and we felt that under the circumstances, if this was going to be heard in camera, which was the decision, that anything related to that should be struck until such times it had been heard.
Section 19A of our procedure bylaw very carefully and succinctly gives us the method at which a notice to motion is read. It is to be read during a meeting, and the member that is reading it is to give a copy to the clerk, which I did that evening, and it says specifically it's to form part of the minutes of that meeting. Why is it not part of the minutes?
Well,
And what gave us the right to retract it from the minutes? Our
Well, it's
procedure
my
bylaw says
yeah,
that it must be form
Okay.
part of the minutes.
yeah, well, what the issue is that, as I understand it, and the lawyer's here to maybe correct me if I'm wrong, but I understand that it really was intended and it should have been submitted in an in-camera session, and that you chose to direct it at an open meeting created liability, and that's why we felt that it not only should it be heard in camera, which it subsequently was, but that the information connected to the tape that was held should be removed as well on advice of solicitor, and that's what we did as well.
The entire notice to motion, Your Worship, the entire notice to motion is factual. It asks questions. It doesn't point the finger at anyone as to wrongdoing.
I think there's some concern about the title. Maybe you can explain about it. You identified, I think, 4 employees by title, as I believe in your motion. Is that not correct?
Yes, Your
Okay.
Worship.
And that was the trigger,
The
the
reason
concern
why
around-
those people were mentioned it's not my motion, by the way, it's Councillor Bestwick's motion. The reason why it was mentioned was because they happened to, one would reasonably believe that they were involved in the drafting of the original motion on May 5th. So that's why they
I
were
recall it
named.
was referring to wrongdoing on their part. Was that not the case?
Well, that seems to be what this is all about, is that there seems to be some people who are misinterpreting the
But let me just
motion.
argue with one at a time here. Are you guys okay?
Yeah. Go ahead, Bill. Or Councillor Bestwick.
Thank you. May I just make a comment on a couple?
Sure.
Let's make it perfectly clear that there's absolutely no allegations of wrongdoings. There is no allegations of wrongdoings contained within the motion, the notice of motion read on July 14th, and there has been no allegations of wrongdoing since. And given the fact that the motion of July 21st was to direct the Director of Human Resources to conduct a chronology of events and report that back. Am I permitted to discuss any portion of that in this open meeting as we're speaking now, or do I run the risk, because I'd like to address the inference of allegations of wrongdoing contained in the notice of motion, because there is none.
Okay, well, I think the easy answer is no, basically, because
I
we
would
haven't
like to
we haven't
seek legal
debated it
advice.
yet.
In terms of what was discussed at the last in-camera council meeting, no, Councillor Bestwick, the community charter is clear that matters that are considered and discussed at an in-camera meeting must be held confidential by all members of the public until those matters are agreed by council as a whole to be released to the public through generally speaking, a rise and report. So to the extent that matters were discussed at an in-camera meeting and there has not been a rise and report in respect of the contents of those discussions, any disclosure of the content of those discussions would be contrary to the community charter.
So then, in fact, if I speak to the notice of motion, where there are 6 whereases, which have all been recorded as being factual, you have then based your position that this notice of motion puts the corporation in a libelous situation?
I did not say libelous. Libel
In a litigation situation?
In a risk of potential liability and a risk of potential human resources issues for the municipality, yes. And that was the basis upon which I suggested to the mayor that council may want to consider dealing with the matter in camera.
And could you please then share with me, since I was not a participant in that meeting as a member of council, to know what specificities inside this notice of motion causes that concern for potential legal consideration?
The whereas clauses raised, in my view, reading the whereas clauses raised issues of concern and could have been interpreted in a way that raised allegations in respect of city staff. Now, whether that was the intention or not, that's not my role to say. I am simply saying, having read the whereas clauses, it raised a concern for me in respect of human resources issues.
That it was written by a layperson, and so the layperson, myself, and for about 6 or 8 weeks ago, or longer, Councillor McKay, no, longer than that, 3 or 4 months ago, last year, Councillor McKay, from his seat, did a motion in collaboration with staff, with whereases attached. Did we run risk because of wording of whereases that we had potential legal concerns with a whereas?
Certainly. I mean, certainly to the extent that a document prepared by the city or individual city representatives can be interpreted in a way that affects individuals or third-party rights, that could give rise to a claim against the city. Now, I'm not suggesting that that was the intention, but in circumstances where there is a great deal of care taken in the manner in which things are written, those can still sometimes lead to risk of litigation, risk of liability to the corporation. And that's where I see my role as the city solicitor, that if there is a risk of litigation or liability to the municipality, which is to be borne by all of the residents of the municipality, as a city solicitor, that is my role. I am not the legal counsel to any individual councillor or to the mayor in and of himself or to staff. My role is as legal advisor to the corporation.
Well, thank you for that explanation. So because the time that I've sat here, I certainly have learned not to have anything loose, to ensure that whatever it is that you're bringing forward, that you bring it forward with as much detail and specifics in it so that there is no opportunity for challenge. So then are you suggesting if the simple 6 whereases are removed, then we can discuss this in open?
In terms of an investigation, in terms of the issues relating to the notice of motion set out a number of whereas clauses, and then and I am going strictly by memory at this stage, set out a number of whereas clauses and then options for council as to potential steps to be taken in respect of what's set out in the whereas clauses. In terms of the issues of the options available to council, it is open to council to deal with those without discussing specifics of the whereas clauses. It's open to council to deal with those at a public meeting if council wishes to do so. Those still do raise issues, human resources issues, because they relate to a third-party investigation of events involving staff, which may result in concerns being raised in respect of the manner in which staff address matters, may raise concerns in respect of which a third-party management company addressed matters, may raise issues that could create liability for the municipality. And if it's done in a public forum, that opens the door to potential liability to the municipality. So when you talk about debating the issues, all of this can be debated at a public meeting. It doesn't have to be in camera. Councillor McKay's made that clear, and it is clear. But when you deal with it at a public meeting, you have to do so with your eyes wide open as to the potential legal implications for the corporation. And that's what I raised as concerns and suggested that perhaps the notice of motion should be dealt with at an in-camera meeting where these issues can be discussed and council as a whole can make a decision as to whether they want the matter to be dealt with at a public meeting, recognizing the risk, or at an in-camera meeting and trying to avoid risk.
Thank you. So you did answer the question that this is, to Councillor McKay's point, that we can discuss it in open, we don't have to go in camera. You've also answered the question that softening or mitigating the potential risk by removing the whereases would soften, mitigate that. Is that correct?
Yes. Now,
Thank you. And you also mentioned that in a report that I believe that's a report to all, that on July 16th there was a recommendation that came forward on July 21st to do a chronology of events, which would, in essence,
Straight. Now, my understanding, Councillor Bestwick, is that was discussed at an in-camera meeting.
so basically what I'm hearing you tell me, unless this council here, right now, votes in favor of discussing this matter in open, we have no hope in hell of discussing this matter in open.
Yes. That is what the statute dictates.
Thank you.
Okay, did you any follow-up?
Oh, yes.
Go ahead.
Okay, so now we're talking about C, G, I, and N. Pardon me, A, C, G, and I. First one, A, personal information, under 90.1, about an identifiable individual who holds or is being considered for a position as an officer, employee, or agent of the municipality or other position appointed by the municipality. In the motion, or the notice to motion, there is no personal information about any staff or member or proposed investigator. The information set out in the notice of motion is in the public domain: their name, their business title, and their role in the city. Would you agree? There is nothing in that notice to motion that has any personal information about any identifiable individual who holds or is being considered to hold an office within the city of Nanaimo.
Again, I don't have the notice of motion in front of me. Right. I don't have the...
That's the notice you entered, is that the one you're referring to?
Yes.
Yeah, and you identified 4 employees.
It says personal information, Your Worship. What personal information other than their title?
Well, let him have a chance to look at it and see.
It mentions...
But by identification of the title identifies the person. You're saying it doesn't make reference to him.
What personal information other than their job title does it mention, Your Worship?
Well, I think maybe when the lawyer has a chance to read it, but my understanding was the reference was made to the fact that there was improper...
Well, I'm trying to go over each and every
just one quick-
clause of 91 that we're talking about.
No, and in terms of this matter going in camera, the resolution to go in camera does not cite Section A, nor does it cite Section B. It is citing Section C, G, I, and N. Those are the bases on which it is proposed that the matter be dealt with at an in-camera meeting.
Okay.
So I think it can be conceded that 8A does not apply.
Fine, thank you. So under C, labor relations or other employee relations, the motion simply directs staff to cooperate with the investigation. The action in this motion does not appear outside the normal course of their duties. You're asking them to cooperate with the investigation by providing records in their possession and telling council about their communications on the issue. That's under C, labor relations or other employee relations. Where in there does it say that it needs to go in camera for that reason? We're just simply asking them to cooperate with an investigation.
When a matter goes in camera, it is not simply whether the matter itself directly raises the issues under which the matter is being taken to an in-camera meeting or discussed to be taken to an in-camera meeting. The question arises whether dealing with the matter in a public fashion would give rise to issues relating to labor relations or other employee relations.
So
And-
are you suggesting that we not hold the investigation in a public forum? Is that what you're suggesting?
Well, I haven't
I don't
suggested
believe he
that
made
at
that
all.
statement. What you're mixing apples and oranges here. What we're saying is
Well, no.
that there's employees involved in this on it too, and let him speak his mind here. He's
Okay,
trying to explain
okay.
that it's the reputation of the individuals working for the city that were at risk, and that was the point that was brought to my attention. You may disagree with that.
Well, asking them to cooperate in an investigation, how does that put their reputation at risk?
I don't know that they were asked to. They were identified in the report.
Yes,
Title.
Mr. City Manager, Mr. So-and-so, Miss So-and-so, please,
I think when you read
Please,
the phrasing
please.
that was used.
no, it says, it asked them to cooperate. That's all. It identified their positions because one would believe that they had an involvement in
I
the
believe the
original
lawyer's
motion.
already answered that.
No, he hasn't.
He just said he gave advice based on the concern for the municipality and the corporation.
So, next one. Litigation or potential litigation. The city has settled any litigation that was involved in the LeaderCast event with the Nanaimo Daily News. So what litigation are we referring to?
I think it was basically any potential litigation.
Thank you for choosing WestJet. Your last flight was
All
selected
right.
amongst thousands of flyers to receive $999 credit towards your next trip.
Who's that?
For more information, press 1 now.
So there's three potential litigants. One is the Nanaimo Daily News. That's been dealt with. The second one are the people who may have bought tickets who were inconvenienced by having the event canceled. Well, we have no indication that anybody is suing us for that. I've heard nothing. And if it's about the city manager or other staff suing the city, then do we have any indication of that?
I don't know that we were ever that specific in the issue, were we? I think we were just talking about in general terms.
Do we have any
liability
of our
the
city employees that are suggesting that they're going to sue us?
I don't know they said that.
That's why we should be in camera.
Yeah, you can't discuss this.
That we're asking them
Hey,
to
just 1 minute. Go
cooperate
ahead.
in an investigation, period. Then we keep bringing up litigation. What litigation?
When I say point of order, you're supposed to stop speaking.
I hadn't finished yet.
Your Worship, can I explain my point?
Sure.
The longer we talk about this, and it just happened, that now we're getting in a real dicey area. And it just happened, and inadvertently, I'm sure it didn't, but the more we speak about this in open, the more difficult
Image.
it gets to speak. The more difficult it gets to speak. And I'm sure our lawyer's sitting over there biting his tongue because we're skirting the issue, and if we sit here long enough, we'll eventually get our in-camera meeting in open. Now, I don't know. But that's not what we want, because there is... Because there are issues, Your Worship, in the procedural motions, C, G, I, N, and B in the community charter. These are the issues that we're dealing with, that the reason why we should be going in camera. You may not like those reasons, but those are the reasons. And we can skirt around it and talk about it and question our lawyer and so on and so forth, but it's going to come down to a vote as to whether we go in camera or not, Your Worship. And we're really getting into a real gray area, a difficult area, because the more questions we ask, the longer this goes on, the more things are going to come out that we don't want coming out, because of the municipality and the liabilities and so on and so forth. And there I go talking about liabilities. So we just can't speak about these things in open. So anyway,
But just to the point is that we did discuss at an in-camera session that it was the majority of council at the time decided that it would be heard in camera, this matter, and that's basically what we're still trying to do.
So let me continue, if I might.
Okay?
And that is, if we are always going to contemplate potential litigation because we ask to do something or we do something, then we're never going to be able to conduct our business. I'll give you an example. We build a stadium. You know what? We're probably going to get sued at some point over an event at that stadium. So are you saying then, by Councillor Greaves' logic, that because there's the possibility at some point that there may be litigation, that we need to do all our business in camera? If we build a sidewalk?
I think
build a sidewalk?
I know where you're going with that, but the point is, we're dealing with the fact that this is a procedural motion, and there were specific reasons why the lawyer decided, in his opinion, that this should be held in camera. Now, I know you disagree with it, and you voted against it, but you weren't on the winning side on it. So the point is, at this time, the vote's been taken, and I'm sorry if you're not happy with the outcome, but that's what the outcome is, and we're going to hear this in camera.
Well, the next one, I don't buy it, because if we install, Your Worship, if we install a sidewalk, at some point in the future, there's going to be potential litigation.
Yeah, but you're not comparing the. The concern here was
It sure
with
is.
staff. Just one second. With staff, the motion that was read out involved staff working for the city of Nanaimo, and that is where the issue comes in. We can't, and we'll never will, build anything that will be exempt from lawsuits for litigation for slip falls and all kinds of things. We all understand that. But this particular issue involved employees of our corporation, and that's where the gray area came in.
So let me carry on. So you know what? I don't think Councillor Bestwick. Now this last one is on the issue of receipt of advice that is subject to solicitor-client privilege, which is I don't think Councillor Bestwick is asking Council to disclose legal advice to the public, nor is such disclosure required. Council doesn't need legal advice on whether to conduct an investigation or not. That's what the motion asks for. We don't need legal advice to whether we're going to conduct an investigation. Council may need legal advice on how to best run the investigation to ensure that the city isn't exposed to unnecessary risks. That could be a friendly amendment to the motion.
Okay? Councillor Bestwick, you're on.
Indeed. And when I was informed on, I believe it was July 21st online, participating, that the notice of motion needed to come through staff first. There's no condition precedent that a notice of motion must go through that channel, period. And therefore I was giving 28 days of advance notice of a notice of motion, of which then there was an intercept that essentially superseded the notice of motion, strategically done, where that motion passed unanimously with, I believe, 5 people present. I would like to know where, and you'll have to indulge me, this notice of motion, whereas the City of Nanaimo entered into a contract for services with the Bank of Ireland Conference Centre Management Company to operate the Bank of Ireland Conference Centre on behalf of the City of Nanaimo, and that neither city staff nor council have authority over the day-to-day operations of VICC by the VICC operator. Whereas the VICC operator entered into one or more contracts with the Nanaimo Daily News and Coast Capital Credit Union, event sponsors, for purposes of simulcasting the LeaderCast conference on May 9th, 2014,
Okay.
LeaderCast event. Whereas Councillor Patchy advised city staff that he would be bringing forward a motion on May
Don't
5th.
know, is this something that we should be doing in this point here?
This notice of motion was read publicly. It was already been in the public domain. There is no violations. My point is, Your Worship, there is absolutely no, in my opinion, there is no allegations contained within inside this. There has been no discussion about this, whereas. Nobody's being accused of anything. There is no material demonstration contained within these 6 statements of whereas, other than fact. So how in the world can a notice of motion that contains nothing but fact be forced to go in camera when we're simply providing options, therefore be it resolved? At which time we have the opportunity as a council not to...
I think you've answered it, have you not? That, in your opinion, you felt that there was a risk to the corporation?
What I advised the corporation was that I was concerned, having read the notice of motion, that there could be issues of potential liability to the city from a human resources standpoint. And the city has received advice at an in-camera meeting following that initial advice from myself, and is proceeding down that road.
Okay.
So let me just follow that up, Your Worship. So there's 1, 2, 3, 4, 5, 6. So I won't ask you to indulge me on all 6 of these whereases, which are just simply based on fact. So when I ask you if we remove whereases, and if we happen to remove the 5th whereas the city manager and manager of legislative services are responsible for providing advice to council regarding compliance with applicable federal and provincial laws, city bylaws, and city policies. And on May 5, 2014, city staff added
Point of order, Your Worship.
Yeah.
the LeaderCast. This is out there. This is public. I'm asking for advice from.
Yeah.
I'm asking for advice from.
But I called point of order, and you're supposed to stop speaking, and the mayor is supposed to say, what's your point?
What's your point?
What's my point? I'm asking.
No, what's his point?
That's the procedure. Next, you'll be reading number 4, and the next you'll be reading number 3, and number 2, and number 1, and you're bringing all these things out in the open again, and that's why we go in camera. That's why. That is
'Cause I think-
exactly why. And the more we talk about it, as I said before, the more we're going to discuss, and I don't know if that's your idea or not, maybe it is, I don't know. You're going to get this in open if it kills you. Good. I don't know.
Well, we have a
You're gonna get it
policy.
in open, you're going to get it in open, we're going to sit here till 7 o'clock, you're going to get it in open. And I don't think we should allow it, Your Worship.
I agree.
Your Worship, so if I could, I am confirming with our legal representation that there are no allegations of wrongdoing of which has been purported contained within this notice of motion. That is my question.
But I think, I'm very uncomfortable debating this.
I'm not debating,
in
I'm
this-
asking a question.
Well, boy, it's pretty close.
Not debating, I'm asking our legal counsel who's sitting in front of us.
I'm not sure at this forum we should use that, answer that. But you want, if you want to give me your advice? Will it put the corporation at risk, in your opinion? Whose phone is that?
That's me and I'm turning it off. I thought it was off.
Don't tell me it's
And
WestJet.
no, I
If
wasn't
it's
booking,
WestJet.
I wasn't booking WestJet, no. I should have got an iPhone.
In terms of the notice of motion, I've already expressed
I know.
the initial concern that I had that the notice of motion raised concerns of potential liability and risk to the corporation.
Yeah.
I appreciate that members of council may not agree with me on that. I am simply saying that my reading of the notice of motion, as well as the reading of a couple of my colleagues, was that it raised potential legal concerns for the city and should be dealt with at an in-camera meeting, or at least considered to be dealt with at an in-camera meeting.
And it was.
And we made-
So at this point, we can, if someone would like to make a motion for the procedural motion?
we've made the motion.
Well, we're going to have to put some closure on this at some point because we've gone around the block again. And is this new information? Okay, go for it then.
So number one, or so on this issue, the legal opinion. Neither the mayor nor council asked for a legal opinion. So under what authority and who hired our legal counsel to give us a legal
I
opinion?
asked for a legal opinion.
You asked for a legal opinion.
And as the mayor and the lawyer came to my office and discussed this and expressed his concern.
A couple of weeks ago, Mr. Chair, I asked you specifically, and you said you'd get back to me, and I haven't heard back from you. I said, there was a meeting held in your office between yourself and another city employee and our legal counsel. Who asked for that meeting?
I don't think this is the right venue. We're not going to discuss that here.
Okay then, how about I ask, did you ask for that meeting?
Yes,
You asked for that meeting.
yes. Through
How did you
staff.
come to that conclusion?
staff.
Through
Because
staff?
I asked staff to, I didn't phone the lawyer myself and say, please come here. Staff organized the lawyer to come. But I was concerned that there was possible risk on it, and it was for that reason.
Based on advice of staff?
The staff didn't really have an opinion so much on it definitively, but saying that this is something that the lawyer should make a decision on, and I agreed.
When I asked you previously, you didn't know, and you said you would check into it.
Yeah. I'm not
So
going to
this is your answer
you.
now?
Yeah, I'm not going to bait this with you, okay? Now, we wasted enough time. You're playing politics here. You've got all the votes here. Good on you.
Your
But
worship,
let's get on with the game.
Mr.
We've got
Chair,
work
I'm
for the
simply
city
trying
to
to
do.
get to the bottom of this.
What is your point?
My point is, when I asked you 2 weeks ago, who asked for the legal opinion, you said, I don't know, I'll have to check into it.
I
Now you're
discussed it with
saying-
staff. Did you not hear what I said?
Go ahead.
I discussed it with staff, and then I asked staff to get a hold of the lawyer to have them come in, and the lawyer came in and met with me, and we discussed it. What part of that are you having a problem with?
Well, I would have liked, as a member of this council, to have been included in that decision.
What a shame. You weren't.
Thank you.
You're welcome. Now, let's move the procedural motion. Okay. You're going to second the motion procedural? Okay. All those in favor? Opposed? Are you opposed? For the
Yes.
motion? Okay.
What's the motion?
Well, they were yelling too loud, so you couldn't hear whether it was
Can you
procedural
let us
motion.
have the vote, please?
Again? Oh, could you record? Please. Go ahead.
Your worship, there was a motion on the floor to proceed with the procedural motion.
Yep.
And you called for the vote.
And it was, I believe, Councillor Pachi, Councillor Johnson, Mayor Rattan, and Councillor Greaves was in favor, and my understanding, although they didn't show their hands, I think Councillor Bestwick and Councillor McKay were opposed.
Certainly.
That's correct?
I'll be happy to show my hand.
No, so the motion passes. So we are now move into the room next door, and we'll continue